Yes, my lord. We have motion on notice for station of time to enter appearance. It's dated the first day of February and filed on the 9th of February. The parties have been served. Sorry to covenant of court, we are ready to move same.
Because I believe it's not opposed, so you move in terms.
As the court pleases, move in terms of our motion paper. Most grateful, my lord.
It's ordered as read.
As the court pleases.
As the court pleases.
My lord, the third defendant has a motion before your lordship. The motion is dated the 14th day of February, but filed on the 15th day of February. That is today, my lord. It is a harmless application. It is an application seeking an order of this honorable court to order the claimant to amend the name of the third defendant. My lord, I don't know if the said application is before your lordship. It is a harmless application.
When did you say it was filed? Okay,
was filed
today. Yes, I have it. Okay. To correct the name of the second defendant.
The third defendant, yes.
The third defendant, yes.
We do have a copy of this application.
The claimant has not been served with the application.
My lord, we've
sent
to their email. It is a harmless application. It's just for
yes, no, I know it's a harmless application, but she just needs to know what application you are asking her to perform some acts. So she cannot perform that act if she doesn't have the process. Do you understand? It was just filed today. She has not been served, and it seeks an order that the claimant be ordered to correct the name of the third defendant. So she needs to. If you were physical in court, I would have asked you to, if you have a copy, to give her so that she will look at it. So now I don't know. Yes, Ms. Osan Sui.
I've actually proved my point well. We cannot blindly accept the application when we've not seen it in person. So we're objecting to removing.
Maybe we can remove the first mark so that we'll just deal with the. Okay, since you're the only one sitting there.
Yes, but no, we're objecting to removing the application because we cannot blindly believe that the application is fitting.
I agree.
So maybe you can move it.
Yes, Mr. Wobodo. Mr. Wobodo.
Yes, my lord.
Can you hear me, Mr. Mwabodo? Yes.
I hear you, my lord.
You know, she has not seen this process at all. So we cannot take the application today. She has not seen it. She does not know what it is. And she's, you know, the claimant is the one that is going to have to perform the acts in the application. You just filed it today. So you cannot take it today, even though as harmless as it may be, but she needs to see it and know what, you know, what, to even know the name you want her to correct it to. So perhaps you will take that application at the next date. It is something we can just correct if we all agree, and we'll make the necessary corrections. And then the subsequent processes will carry the correct name. But we can't hear the application when she hasn't seen what it is. Because you may ask her to correct the name and she says, but that's not the name I want to, the person I want to see. So she needs to see it.
All
right, so that leaves us with the notice of preliminary objection.
Yes, my lord. I want to draw the court attention to the application filed by the third defendant. We are not opposing, however, this is the first application they are filing. They have not regularized their appearance. So I don't know if they have right, their memo is not before the court. They have not filed a defense or challenging the suit. And they are just filing a motion to correct name. They ought to do the needful before asking for the court order. But as it stands, they are not even present in court.
Yeah. Yes, Mr. Mobodo, you had Mr. Majoi.
My lord, the intent and phase of filing a notice of a memorandum of appearance is to see that an appearance has been entered for a party in a proceeding. As it is, my lord, the name of which the claimant has brought the third defendant to the court happens to be its former name, which has been changed sometime in 2019. And our application before this honorable court says it all. However, same is not yet for hearing because of the position of the claimant that he has not received our processes. So we don't want to proceed on a wrong premise by entering an appearance for a name which we are no longer using, or enter an appearance for a new name which is different on the record of the court. So that is the situation we found ourselves in.
Okay, so this name, yes, the name in which the third defendant was sued or is sued is a former name.
Yes, as the court.
Probably the name that the claimant knew it by. So if since the third defendant recognizes that, you know, it's the person intended to be sued, won't it be tidier to enter appearance and then make this application?
Court pleases.
As the court pleases.
So I think by the next date, yes, the council will enter appearance and then can also take this application so that we'll know who is before the court.
As the court pleases. Take the hint of the court.
I don't know if Mr. Mobodo heard me.
As the court pleases. Yes, my lord, I heard it.
Yes, Mr. Amaju, you have seen the notice of preliminary objection. The claimant is still within time to respond.
Very well, my lord.
So we have to register. May 25th, Council. Yes, to hear the notice of preliminary objection.
May 25 or 26.
Convenient, my lord.
May 25. May 25, Wednesday, covenant, Lord.
So since it is to hear the preliminary objection, do we, maybe it should be physical.
Very well, my lord.
So we'll just leave the virtual for the day that the witness is going to give evidence.
As court pleases.
Ms.
Please.
Osanyi Tui.
Court pleases, it's fine, my lord.
Okay. So the matter is adjourned to 25th May to hear the notice of preliminary objection. It shall be physical.
Court pleases.
Court pleases.
Uh,
Okay. Let's see that.
So, okay.